Live and direct, live and I take no jive.
Legalize it.
Come here, much can a koala bear? Koala bear, koala bear. Koala bear. Barry pulls a joint out of his pocket. Bill says, "Great, Barry, a reefer."
Hi, and welcome back. It's another episode of the Koala Podcast. I'm just going to speak to some authors in this episode, which is quite exciting because I've come across a forthcoming book that's going to be published on the 28th of May. So the blurb tells me intellectual property and cannabis I was about to say hardcover. Of course, it's a hardcover because it's a law book, and it's by Natalie Corthésy, who I've got on the show. She's the editor, and she's based in Jamaica and is a academic at the University of West Indies. Enrico Bonadio, who's based in London, and also there's another editor who I will mention, but she's not joining us, Yentel Williams. Natalie and Enrico, welcome to the Koala Podcast. Thanks for taking time to speak to us. How did this all come about? Natalie, I'll ask you first. Do you teach cannabis law prior to this? Is that part of what you're teaching at the university?
Absolutely not, Sean. We don't have a cannabis law.
That's why I asked the question, because I'm trying to persuade universities all over the world that really start getting into this, and especially law schools in first year really get students talking about this issue, because it's a great way to understand new industries of the 21st century, but something that connects a whole lot of other dots together. So I'm really fascinated by law schools and cannabis law, and so far their lack of interest in sort of spreading the word and teaching more about cannabis and cannabis related law.
Let me interrupt you there. It would be untrue to say that there is no interest. But you asked me specifically about cannabis law, and that is not currently being taught. However, at the University of the West Indies Mona campus, there is a cannabis group, which is a committee which pulls together an interdisciplinary, disciplinary group of colleagues campus-wide from the different faculties, so that we can have a single place where, as an academic community, we share and discuss the work that we're doing related to cannabis. So initially, the cannabis group, the UWI Mona Cannabis Group, was spearheaded by the Faculty of Medicine. And the Faculty of Medicine at the University of the West Indies Mona has for many, many years been very involved with research in cannabis related matters, from having a look at different types of cannabis, using cannabis in medical treatment, having a look at assessing cannabis plants for properties, medicinal and otherwise, for a long time. They've been involved certainly with the development of the law, and with consultations and so on. Various members have been a part of that. And so the idea was to expand it to other faculties on the campus, that we realized there were other members who were doing work. So for example, I can think of my colleague, Dr. Marshall, who he has been looking at growing cannabis species, looking at plant varieties and so on, but he's in the natural sciences department. And then I can think of, for example, in the economics department, we had another colleague who was looking at the economics of cannabis and the whole trade politics aspect of it. And then there was myself, admittedly at the time when I became interested in looking at law related to cannabis, but very specifically around geographical indications, I have to say, in a very limited scope. The cannabis group came to my attention, and I, of course, quickly joined the UWI Mona's cannabis group. And so all of that to say that the interest around the umbrella of cannabis and its study as an academic pursuit has been on the UWM Mona campus for some time. Cannabis law course, not yet. How we came around to the idea of the book, myself and Enrico have been collaborating together for some time now. We had a preceding project on geographical indications, which was really the second project that Enrico and I had been working on. We did one previously on artificial intelligence. And so there is, I would say, a soft MOU between City of London and Mona Law. And so this was really the idea, well, let's do another project. And so out of the geographical indications project that we did in Jamaica, and having interacted with a number of different GI stakeholders, we spoke with Castro, we spoke with honey, we spoke with coffee, we spoke with rum, and so on. And of course, we spoke to cannabis. I said, look, there's a gap. There's a real gap here. And I think that there's an opportunity to put forward another project, but focused on cannabis, because nowhere in the world have we yet seen a geographical indication for cannabis. So our push to write the book really came out of this project focused on geographical indications in particular. My expertise really is on intellectual property protection of country names. This is what I've been pursuing for about a decade and more. And of course, Enrico also has been doing quite a lot of work on geographical indications. Himself and another colleague, Andrea Zapiela, they've just put out a book just this year on the future of geographical indications. He's editor along with Andreas. I'm a contributor to that book, along also with Yentil, our co-editor. She also has contributed to that book on the future of geographical indications. So the idea for this book came out of the idea of what would be a good area to expand into with the GI focus. From that point of departure, Sean, we thought, how could we take an interdisciplinary look at it? We thought that intellectual property was obviously where we had our own personal sweet spot, but we wanted to see how we could bring to bear the other aspects, because we felt that you really needed all the different pieces of the puzzle to come together to have a complete picture about why cannabis was, let's say, challenged in the way that you put it. Why isn't it further along, right? And so the book, quite intuitively, is organized in 3 sections. In the first section, we focus quite pointedly on intellectual property.
Yep.
So we look at copyright, trademarks, patents, of course, geographical indications, plain packaging, and so on, traditional knowledge. And then when we come to the second section of the book, we had the idea to look at case studies. And then I will allow Enrico to tell us a little bit about the case studies we chose. And Enrico, you could also mention the third section, the interdisciplinary third section.
Yeah, because I mean, I'm interested in the case studies because I'm really interested to know which jurisdictions you managed to pick up information from and under what under what regulations and legislation these cases actually occurred.
Yes, I mean, the book is divided in 4 different parts. Part 1 is about branding cannabis. Part 2 is about copyright, image rights, packaging, and plant varieties rights. Part 3 is about specific case studies from selected jurisdictions. And Part 4 is more multidisciplinary with a focus on economic analysis, sociological analysis, and developmental analysis. So, starting from the first part, branding, I mean, our contributors, by the way, our contributors, the chapters, authors, come from very different areas of the world, which shows how the collective work we have been supervising is truly international. We have contributions from Canada, US, different countries in Europe, Uruguay, of course, Jamaica, and so on and so forth. So, part one is about branding because, brands are quite relevant when it comes to selling this product in the countries where it is legal and regulated. So we have a much needed analysis of trademark aspects of cannabis in the US. I mean, this was very important because many states in the US have legalized the product, and there is a market, which in many cases is a thriving market. It produces quite significant numbers there. So for example, in America we have these cannabis companies, distributors are experiencing some difficulties coming from the fact that at federal level the substance is prohibited, but at state level many states do allow trade, consumption, and therefore businesses in this sector, they need to navigate through
Well, a
quite
whole range of issues, that's for sure.
yes, they are caught up in this struggle between the federal and the state level. And this chapter by our colleague, a trademark attorney, Luke Zimmerman, is really very
Yes, I've
clear.
spoken to Luke in the past.
Exactly, and Luke is very clear in his chapter. It gives really a roadmap on how to navigate this maze of legal regulations at federal and state
Well, also
level.
different state regulations, because every state is the same but slightly different, of course, because that's how they like to run it there.
Yeah, which might have an impact on interstate trade, of course. And then we have a chapter on the European Union scenario, because there have been several decisions, a few decisions, I would say, by the European Court of Justice on the morality of certain cannabis brands, because several trademark laws in the world, including in the European Union, do not allow the registration of trademarks which are considered immoral. And of course, marijuana sometimes falls within this morality trap, let's say. And then, of course, another important chapter by our co-editor, Yentil Williams, about GIs and cannabis. There is an ever-growing importance of geographical provenance of cannabis, in the sense that consumers of this product tend to put weight on the geographical origin of the product as a driver for purchasing decisions, and therefore, GI laws has become important. So part one is about branding. Part two is about different IP rights in relation to cannabis. For example, moral rights of those who endorse, celebrity who endorse, let's say, such products, whether these endorsement might, be violating some, legislations around the world. And of course, this is very relevant also as far image rights are concerned, because what we have witnessed is some sport celebrity endorsing the product, and therefore lending his or her image for this product. Myself, with my co-author Akshita Roktaji, we have looked in our chapter at packaging. Because, of course, there are many jurisdictions, including at state level in the US, which mandate what is called standardized packaging, a measure which has always been adopted for tobacco, already in many countries. So what we have witnessed here is a a regulation which mimics or parallels the standardized packaging regulation, which is
as far as I can work out, the industry is being very inventive to find ways to get around that at the moment.
absolutely. And of course, because the product is harmful, and therefore there is the need of restrict the ability of cannabis distributor on how to populate the packaging, and therefore there are requirements which vary different degrees of regulation here, depending on the jurisdiction. And then the last chapter in this part is about plant varieties right. Plant varieties right is another intellectual property right which specifically protect innovation in the plant sector. And we have a chapter on the US plant variety protection of cannabis. Then part 3 is about specific case studies. And here we have looked at countries which have legalized the product, in addition to the US that has been covered in the other parts. So, for example, we have the chapter by my co-editor Natalie, who is here with us, about the development of an IP protection strategy in Jamaica for Jamaican cannabis. So there is a focus on how IP protection has been planned, is being adopted and conducted in the specific island of Jamaica. Then we have a much needed chapter on Canada, because as probably many listeners to this podcast know, Canada legalized the product, I think, in 2018, back 2018. Of course, there has been some challenges. There are still some challenges, but, Canada is a very good case study for, checking how IP is used in relation to this plant. And then other 2 countries, of course, the Netherlands. No, we could not rule out the Netherlands because there the product has been tolerated for many decades. And our contributor there, Lotte Anamet, has analyzed several case law from Dutch courts on branding, on other IP rights. And then another last chapter in this part about Uruguay, another country which has legalized the products, although there is no possibility of branding there because there is much regulation there. So it's a heavily regulated even when it comes to IP. So different degrees of regulation, as you can see. Part 4, the last part, is about more, as I said, developmental, economic, and sociological issues. There is a chapter, a very nice chapter by Marcus Goffe, our Jamaican colleague, a legal scholar coming from Jamaica, who has expanded on the intersection between cannabis and traditional knowledge, right? Especially from an indigenous perspective, an indigenous rights-based access and benefit sharing framework perspective. A very interesting chapter. Then we have an economic analysis by an economist based in Rome, in Italy, who has looked at the economics of IP protection for cannabis by analyzing many patents that have been obtained, especially in the US, which have been obtained to protect new technological solutions in this sector. Another interesting chapter in this part has been authored by Brian Kahn, another economist specialized in IP based in Trinidad, so in the Caribbean, who has written a quite powerful chapter on the critical development theory in cannabis by also looking at colonization and the impact of colonization on this plant. Last but not the least, a chapter by Toby Mursom on the historical and sociological anthropology of the African origins of Jamaican cannabis. Here, Toby takes us in a historical journey, where the plant has been first cultivated and then traveled from an area to another area, especially in Africa. And then we have an epilogue. We have also a prologue written by Professor Spiros Magnatis from Queen's Mary, and then we have an epilogue from Andrea Zappalaio, a GI expert based in England, in Leeds, who has written this epilogue to the book. So I can conclude by saying that this is a really worldwide collective effort, no, from different jurisdiction, different point of views, and different IP rights. We analyze so many IP rights, not just the traditional ones, the most known ones, such as trademarks, patents, and copyright. But we go further. We look at GIs, we look at plant varieties right, moral rights, image rights, packaging rights. It's really meant to be holistic vision of the whole panorama.
So, Natalie, I wanted to talk to you a bit about Jamaica and what legislation has actually been enacted to protect some of these issues that you're talking about in terms of native rights, indigenous rights, and also developing Jamaican IP. Because I'm very interested in this because you're so close to the US and you've had so many US businesses coming onto the island to generate revenue for themselves. How is Jamaica defending itself?
Well, I'm not sure I would describe it that way, to be honest.
Mm-hmm.
I would say that as far back as 2001, there was a National Commission on Ganja that was chaired by late Professor Barry Shavans. And the findings were presented to the Prime Minister with a view to guiding policy towards a regime of, I guess, what you could describe as decriminalization. There was indeed an argument being made quite forcefully that Jamaica was a country that had an entire community that was using, well, the Jamaican word is ganja, as a sacrament in the religion of the Rastafarian community. And that beyond the Rastafarian community, there was quite widespread use of the plant recreationally, and that there was a significant number of persons who were being punished in the criminal law for their use, sale, distribution of ganja, when in fact perhaps the resources were not best being used in terms of what was happening in the broader sphere of the community and trying to fight against perhaps more significant crimes, if I could put it that way. Jump forward to 2013, where the House again was being encouraged to consider, how could Jamaica optimize the economic potential for cannabis research and use of cannabis for medicinal purposes. And so what we really see happening is a move towards, if I could classify it this way, two separate ends. The first end was to address the socio-cultural problem of allowing the Rastafarian community and persons who used it as some sort of sacrament in their religion to be able to continue to use that within some guidelines.
Yeah.
So that was then entrenched. And then on another prong, what we see was permission for there to be small scale, let's call it home style, no more than a small number of plants in your backyard, no more than 2 ounces of something to smoke in your pocket. We will permit that. So it's not that there was legalization, but rather that there was decriminalization. What we saw was the creation of a cannabis licensing authority. And I would say perhaps the most obvious objective of this organization was to provide a focal point for growing cannabis with a view to producing medicinal related products derived from cannabis. And so the legislation makes this distinction between, if I could loosely describe it, what would be cannabis and permissible and what would be ganja and not permissible, if I could explain it in that layman's way. And essentially, in my chapter, I explore the idea of the challenges that this then poses, because by and large, what Jamaica was known for and what Jamaica has always been good at was producing ganja. And so, if what you want to do is to create an economic springboard for the industry, actually, we don't have a history of producing medicinal cannabis. That's what we did not have. And so, what we saw was the arrival of outside forces who were wondering whether this decriminalization, the creation of this cannabis licensing authority, was this now a business opportunity for us to come to Jamaica, benefit from the nation brand Jamaica for ganja, and sort of springboard our cannabis line. And this proved to be very challenging. I've spoken to some of the stakeholders who tried to come and do this, because then you had to completely change the way that you were farming. You had to completely change the way that you were processing, and getting local persons on the ground to understand industry standards of what would be expected to produce an international quality product to meet the grade was difficult. The infrastructure also not present. So, for example, at the UWI Mona is the place where, if you wanted to get an assessment of what you'd grown and you wanted to say, give me a report on this batch, they just can't handle that sort of volume. But without that sort of regulation hardware, as it was, the industry has not effectively been able to even maximize at the cannabis side of things.
We haven't got long to go, but before I talk about the book again quickly, are the legislators thinking about moving to the next step and developing legislation on both the medicinal and the ganja side, or is that conversation ended and everybody has to work within the strictures that currently exist?
I do not believe that the conversation is ever over. I think the Cannabis Licensing Authority of Jamaica has come a far way of streamlining how they manage cannabis, licensing persons who want to grow, distribute, produce cannabis-related products. I think there has been a number of success stories, not just for the government, but for individuals. But I think that a large number of persons who would wish to enjoy some of the benefits of this economic advance are struggling, because really what they're growing is ganja. Yeah. So it needs a rethink about what Jamaica really does well and how we can allow them to do it well legally.
Well, no, I'd love to talk to you in another episode about this at some point, because it's a fascinating topic, and not many people are. Everybody was excited about it 5 years ago, but not many people are talking about it now. But I'm down to my last few minutes, so I wanted to just give some people some more information about where they can get the book from, who the publisher is, and any other of that sort of book blurb sort of information. Enrico?
Yes, I mean the book will be published by Elgar in a few months. So
Edward Elgar.
Edward Elgar is a leading publisher, especially in the field of law and policy, and the field of intellectual property. Intellectual property, especially, I think, is the publisher which publishes more IP books than anybody else.
Absolutely.
So I think
you can do pre-orders now, Enrico. They're accepting pre-orders.
They're accepting pre-orders. So the book is set to be published in June, at some point in June, and will be available everywhere in the world, because of course Elgar is a very strong publisher with offices in Europe, in the UK, and I guess the market for this book will be broad. Of course, the United States, Europe, and the countries which have legalized, but not only